Now, earlier this week on the show, you may have seen that we spoke to the Hawks about this issue and asked if Duduzane Zuma being shackled was petty or political even. The elite police unit said then that it was simply procedural at the Commercial Crimes Court in Johannesburg. All alleged offenders, it said, there were chained, and that's at the court's discretion. But, of course, a new twist, and we're hearing from the Justice and Correctional Services Minister, Michael Masutha. He joins us in studio now. Thank you for being with us, Minister.
Thank you for the opportunity, and evening to the viewers.
So what you're saying is very different to what the Hawks said.
Well, I don't know what the Hawks said to you.
So they said that the Commercial Crimes Court has the discretion to decide, and in fact it always puts prisoners or alleged offenders in shackles. That's what it does for each and every offender.
That's where the problem starts. That's not what the law says. That's not what the Constitution requires. I did get that sense that even in this instance the rationale was that there were others who had been shackled, and they were concerned that an impression shouldn't be created because of the social status of the accused concerned having a bearing. In other words, unjustified differentiated treatment. I further understand that Mr. Duduzane Zuma himself subjected himself to this because he insisted that he didn't want differentiated treatment, and that his lawyers were consulted about this to say this is the procedure that's always followed. All of that is wrong. It's not up to Mr. Duduzane to have decided whether he should be shackled or not. It is the prerogative of the justice system, and it was irrelevant whether his lawyers cooperated or he himself cooperated. What should apply is the rule of law.
And what does that rule of law say? I mean, does it say what everybody's been talking about? He's not a violent criminal. He handed himself over. So it does look heavy-handed, I suppose.
Yes. There's something we need to clarify about how the justice system works or should work. Firstly, the purpose of arrest, restraining a person, and all such detention, etc., should not be seen as a form of punishment or embarrassment of an accused person, but as a means at the disposal of the justice system to secure the attendance of an accused to stand trial in a secure environment, ensuring that neither his or hers security or that of the public or even of the officers who are handling them lives are at risk, and considerations of that kind. So in instances where somebody presents themselves to the justice system and say, I hear you want to talk to me, here I am, I'm presenting myself, that person clearly is willing to cooperate. There is no need to be heavy-handed in a situation like that.
So it should be based on the risk that person poses to society, and in your view he posed no risk?
Even to themselves. We hear that 6 months earlier somebody had jumped out of the 7th floor to their death, who was an accused person in that same building. So indeed consideration should also be taken of the security and safety of the accused person. But beyond that, like I said, shackling a person should not be used as a way of, and the whole idea that we should do this because we've done it to others, and if we don't do it to you, others will complain. That's not how the justice system works. That's not how the equality clause in the Constitution or Bill of Rights says.
So you are publicly criticizing one of the courts, it seems, because we understand this is how the court works. You're contradicting the Hawks. Is it worth it to you to weigh in on this matter? And have you spoken to the court and the Hawks themselves?
I visited the court. You may be aware I've been off sick for the last 2 weeks by doctor's orders, and I made sure that I don't miss on the Imbizo week called by the President. My first stop was to visit that court, and not so much because of the incident involving a high-profile person, but because when I got the initial report in writing on the circumstances, I immediately got concerned. And I felt that I needed to appraise myself fully of the circumstances, and my conclusion was that it was all wrong and it needs to be corrected. Amongst the solutions that we're looking at, for example, is in the immediate to make sure that nobody who appears for the first time is dealt with in that building, that they get to appear elsewhere, especially if they come as an arrested person, unless they are appearing on warning or having been subpoenaed, because there are other ways of securing the attendance of a person in court, and arrest and all the restraints that are used in relation to somebody who's subjected to arrest are not the only ways through which you can secure a person's attendance.
So this won't happen again. You've made sure of that, basically.
Well, the position is that there are cells at the bottom of the building. There are people who arrive there under arrest, who are then ferried to the court. So in the immediate, I do not want to definitely say that I do not want to disrupt the workings of the court, but where restraint methods are used, they have to be used in compliance, as I said, with the jurisprudence that is there that has set the guidelines under what circumstances people must be restrained.
There's been a whole lot of claims, that this was politically motivated. Can we lay those to rest at least? You've talked about this building, and just explain, because it sounds like it's not a heavily secured court building. It's in another building. You say it's not even good enough for offenders to appear. So are they shackling people, Minister, to ensure that they don't escape? Is that the idea?
This building belonged to a commercial bank that was purchased by a property developer or owner, who then leased it through Public Works for use by the Department of Justice. It hosts a number of justice services, including the Special Commercial Crimes Court. The first to the third floor of the building has at least 4 courtrooms that are dedicated for that purpose, the fourth having just been developed recently. Clearly, from the onset, the building was never designed. I mean, the 2 cells that are situated at the bottom of the building in a parking area clearly were something that was of an improvisation. There is a blueprint in the design of criminal courts in the country, and clearly this was an arrangement that was never meant from the beginning to serve that purpose. So what we're looking at is, and I think the rationale behind it is because generally commercial crimes, white-collar crimes, issues of corruption, etc., are generally regarded as involving accused persons who are generally non-violent, who are not prone to escape and those kind of issues. Probably they expected people would be coming in suits and not shackled and accompanied, not in any form of restraint, etc. Reality is that there are accused persons that get delivered there under arrest, and there is shackling between the cells and the courtrooms. What's worse in this case is that they went further and refused to unshackle the accused when they were already in court appearing before the magistrate. I cannot see the rational basis for that, because you can only shackle somebody because of security considerations.
All right, so you've made yourself clear on this point, and I believe you were visiting a whole lot of courts. Minister, on this show, we've spoken to authorities who have described the jam-packed prisons. You have awaiting trial prisoners waiting for longer than any sentence they could receive. Then they go into the court system. What would you say about the state of our court system right now? Is it serving the people who need justice and taxpayers who need protection?
Well, certainly. But the real solution, even if we were to double the number of prisons, double the number of courts in the country, an infrastructure which we will never afford anytime soon, given the economic constraints that our country is experiencing and will certainly in the near future, we cannot envisage a situation where we will ever have sufficient capacity. Maybe the Dutch should give us some ideas as to how they ended up with 19 prisons being closed down because of lack of clientele. So we do have a challenge of high levels of crime in this country. The more effective the police are in effecting arrests, that translates in pressure on our side at Correctional Services. We have had to scale down on the staffing because of financial constraints. We are constrained in terms of infrastructure development. All of these things contribute to the ever-increasing pressure on our infrastructure and on our staff as well, and other resources. So the solution ultimately for South Africa is we have to fast-track the socio-economic interventions that will ensure that young, especially black people out there who are filling up our prisons are actually engaged in more constructive activity in society for their own gain and for their families and communities.
All right. I hope we can talk about that in future. It raises a whole new dimension, but thank you for being with us tonight. Justice Minister Michael Masutha. We'll take a short break.